SJC-12500, J. Patel and another, v. Leo Martin and others.
Mr. Brooks, good morning. Give us a moment until we get the clock going. You may proceed.
Thank you, and good morning. May it please the court. Peter Brooks for the appellants and the defendants below. With me this morning is Gregory Boucher. This is an interlocutory appeal that presents two issues for review. The first, which I believe is an issue of first impression, is whether an order allowing an attorney to divulge confidential communications with his client is immediately appealable under the present execution doctrine. The second issue that I want to address this morning is the judge's finding below that no attorney-client relationship was established, and our argument that that is clearly erroneous under the substantial and mostly uncontradicted evidence that we presented at a two-day evidentiary hearing on this motion. So let me first address, if I may, the present execution argument. The court's very familiar that this is a long-recognized exception to the general rule that only final judgments are appealable. But the present execution doctrine has not, to my knowledge, been applied in a order reviewing an attorney-client privilege issue. It has been applied in many other cases. It's been applied to attorney disqualification orders, in which the present execution doctrine has allowed an immediate full panel appeal of that kind of an order. It's routinely invoked when there's a review sought of a motion to dismiss, when sovereign immunity is at issue. It's been applied in a case in which a partnership was ordered to be wound up and its assets distributed to its partners before final judgment. It's been applied when debtors' assets were ordered to be liquidated before a final judgment. This court did previously review an order allowing disclosure of attorney-client privilege, but did not apply the present execution doctrine because that underlying order had been certified by a single justice for appeal, and that's the Chambers versus Gold Medal case. Our position is that we fit perfectly within the confines of well-established present execution doctrine. We have here an interlocutory order allowing an attorney to disclose what we claim are privileged communications over a 5 or longer month period of time. Once that disclosure is made, it can't be effectively undone by going to trial and having an appeal after a final judgment. Essentially, the information is out. The attorney-client privilege has been breached irreparably, and the proverbial cat is out of the bag.
But you can also bring this as a single justice matter, like in Chambers, or even in the attorney disqualification case, which Bauer, I can't remember, it's Bowers, where they talk about it could have been brought as a 211-3, but it wasn't. So why isn't that a better vehicle? Then a single justice can decide sort of whether it rises to the level of shutting down the whole case or not. Because otherwise we sit here years later, dealing with this.
Well, we did petition a single justice of the appeals court, and the single justice petition was stayed based upon the decision of that single justice that full panel review was likely to be available, and we had filed a notice of appeal. We went both routes.
But I guess the question is, why does this have to be present execution as opposed to a normal single justice process? The present execution takes the whole case up and shuts the whole thing down. And it just seems like that's, I don't know, it's a question, not.
So, I think the standard of review for a single justice is very different from full panel review. With full panel review, there's de novo review of questions of law, de novo review of mixed questions of law and fact. I think there's far more discretion given to a single justice and deference to a motion judge's decision. But this court has allowed full panel review under the present execution doctrine on many occasions, and has never determined that single justice review would be alternative.
Now, we hear these matters a lot, but generally in the context of a person going to contempt. Would it matter here if the attorney in this case says, I believe the conversation was privileged and I will need to go into contempt and then appeal the contempt order? Here, of course, the attorney says, no, it was not privileged, I'm happy to testify to it.
Right. So, I mean, in the Borman case of this court, it was found that the reason that the order invoking the Fifth Amendment was not available for review under present execution was because the wife in that case could disregard the order, have the sanction imposed, and then review it. So I think under our court's precedent, yes, it would matter if that was a remedy that was available, an alternative. I think it's rather harsh to force what would be a lawyer in this case to face a contempt assessment against him or her for not answering questions and then taking that up on appeal. But that was also the position of the federal court under the collateral order doctrine in the Mohawk case, which was that that was a remedy that was available in that case as well, to disobey the order, be found in contempt, and then appeal it at that point.
Do we also have to find that this attorney-client privilege issue is collateral to the controversy for the present execution? And it seems, with all the interest in the deposition and otherwise, that it isn't.
Well, it doesn't go to the underlying merits of the case. This is a simple contract dispute between the parties, whether an assignment of a purchase and sale agreement was breached by not getting written consent. So the disclosure issue of the lawyer is a true collateral issue, just like a disqualification order is kind of collateral to the underlying dispute. But you don't need to review the merits of this case in any respect. It's really just, was there an attorney-client relationship here so that those communications were privileged?
And if we were to force an attorney to go into contempt, I know here the person's willing to testify, would that subject that attorney potentially to professional conduct consequences?
I think it would. And I think you're putting that attorney in a very difficult position where for a client, and to protect a client, he's going into contempt, and if he's wrong about his judgment and the contempt decision is upheld on appeal, he's got an ethical issue at that point that he might have to deal with. I just think it's an unfair position to look to force somebody to violate a court order. It's not something we want to be encouraging, and then appealing from the decision violating that court order.
If we can turn to the merits, your position, I understand, is that the attorney, Mr. Levin, jointly represented you and the Masons.
That's correct, Your Honor.
So if that were true, isn't it true that when there's a joint representation, there is no privilege among those two, there's a privilege as to outsiders, but not with regard to those who he or she is jointly representing?
Yes, the general rule is if there's a common interest between those joint clients, there is no privilege that they may maintain in a dispute between the two of them. But it means a third party would not have access. The issue we have here is we agree with the motion judge that there was no common interest between the buyer and seller of real estate. That is an adverse relationship. Yes, they have a common interest in getting the property sold, but the representation of a buyer and the representation of a seller in a transaction such as this is very different. What we believe we have here is a conflicted situation in which the lawyer represented both the buyer and the seller in a very complex commercial transaction involving millions of dollars.
But I understand it to be the position of your clients that you understood that he was also representing the Masons.
Correct, they did.
And there is a common interest in terms of having that transaction be done expeditiously with attorney's fees to a minimum. Would that not be served by having a single attorney essentially handle the paperwork? I mean, I understand that it's a difference if you're truly in negotiations, but you seem to want to do that.
Well, I think that was the agreement here. I think there was testimony that the client was told that it would make the transaction easier for Attorney Levin to represent both sides. Rule 1.7 of the Rules of Professional Conduct has a comment that says a lawyer may not represent the buyer and the seller in connection with the purchase and sale of a business, and indeed cannot even represent one of those parties on other unrelated matters at the same time he's representing an adverse party. So I think here there might be a common interest. As we said, the common interest to get the transaction done, to get it done as quickly and easily as possible. But I think fundamentally, a lawyer can't represent the buyer and seller with their adverse interests in this situation.
Can you have it both ways? I mean, the trustees here wanted Mr. Levin to do precisely what he did. You knew that he was jointly representing both sides. You should have known that he would have needed a letter from each of you waiving the conflict. But why should you be, when you entered into a joint representation, why should you not be subject to the rules of privilege that say if you're jointly represented and all parties agree that you're jointly represented, then there's no privilege between you?
Well, that would be between us, right. So that is not the issue present here. We have a third party here, not one of the joint clients, who's seeking to discover confidential communications.
But the Masons were also jointly represented by Mr. Levin, and you knew that.
We knew that. We still maintain that our communications directly with Mr. Levin were protected by the attorney-client privilege. If you look at Wigmore, the treatise on Wigmore, he says when a lawyer represents two different parties with adverse interests, both of those parties may assert the attorney-client privilege because the clients understand and anticipate that those communications are going to be held confidential. And that whole concept was decided and discussed in Eureka versus Chicago Title, which is a decision out of the D.C. Circuit from quite a few years ago.
You've got an in-state. Doesn't RFF Family Partnership versus Burns and Levinson support you? The black letter law is that when an attorney represents two clients whose interests are adverse, the communications are privileged against each other, notwithstanding the lawyer's misconduct. So you have, right.
That's the same proposition of Wigmore and the Eureka case. It's only if there's a common interest that there is no privilege in a dispute between those two parties. If there's no common interest, if there's an adverse interest, the privilege can be maintained by both of the parties. And I'm certain in this case, the Masons would maintain that their direct communications with Attorney Levin were protected by the attorney-client privilege, just as Mr. Martin and Mr. Marcus, in this case, believe that their communications were protected when they were in confidence with Attorney Levin. And the evidence here, I just think it's overwhelming that there was an attorney-client relationship. Attorney Levin had been their lawyer for 25 years, doing hundreds of transactions with them.
Look, everyone's trying to save a buck, it looks like. They're having one lawyer do the whole transaction, and then they're bringing in somebody's sister or something. I can't remember who the other lawyer is who's not really doing anything. So,
did not even know that she had been mentioned, named in the purchase and sale agreement, never provided any advice, never knew that she was involved at all. They plugged her name into a purchase and sale agreement. Attorney Levin never spoke with that attorney. He dealt directly with Mr. Martin and Mr. Marcus in the negotiation and drafting of this purchase and sale agreement.
And he was paid, wasn't he?
Excuse me?
And he was paid.
He was paid by, we paid half the bill. There's a bill that says Masons, one half bill, $2,500. He billed us. He admitted in his own testimony during the evidentiary hearing that he gave legal advice to Mr. Martin and Mr. Marcus on a regular basis over that 5-month period. Questions about the condominium structure, questions about permitting, general questions and issues that needed to be resolved. This was a complex transaction.
Could he have done this with the written permission? If he'd gotten the written consent, it would have been fine, right?
So I don't know whether this is one of those conflicts that can't be waived even by informed consent. There are certainly certain conflicts. You can't represent the plaintiff and a defendant in a lawsuit, no matter what consent there might be to that. I think representing both the buyer and seller in a complex commercial transaction may be, not certain, but may be one of those non-waivable conflicts. In this case, there's no evidence that the Masons knew that Levin was continuing to represent them. So I see my time is about up if there's no further questions.
Just one question,
Yes.
sir, and that would be, if we agreed that this was appealable as under present execution, would this have any consequences for other kinds of privileges?
Well, I think the attorney-client privilege is definitely unique. I mean, this court has said that it's a critical element of the rule of law in a democracy. So I think it stands on a different footing from a normal discovery order, compelling discovery or compelling testimony. And it's a unique situation here because we have an attorney who's prepared to testify. He's not going to assert the attorney-client privilege.
Why is it separable from the merits? Because clearly this testimony is important, or we wouldn't be fighting over it, right?
I mean, we don't know what the lawyer's going to say, so, but anytime your lawyer, who you've been working with for 25 years, is permitted to disclose confidential communications concerning a transaction that went on over 5 months, it's a very significant
I
issue.
understand it's significant. I'm just trying to understand why it's separable from the merits, because like the attorney disqualification issue, clearly separate from the merits, you know. There's no doubt it's different. Sovereign immunity, we've decided this thing isn't litigable, if that's a word. But I'm just not sure I understand why this is separable from the merits.
Well, I guess by separable, it has nothing to do with the evidence that's going to be presented in the trial.
Of course it does. If you get this evidence, you wouldn't want it if this evidence weren't meaningful.
Well, first of all, we don't know how it would be meaningful. We don't know whether it would be relevant evidence at trial or ever presented at trial. But I think under the collateral order requirement, as long as you're not required to delve into the merits of the underlying breach of contract claim here and look at whether the assignment, whether consent was obtained or not, I mean, that's the underlying case. And none of that is before you nor needs to be before you to decide this issue. Thank you.
Okay, thank you. Mr. Lawler,
Thank you.
good morning.
If it may please the court, David Lawler, on behalf of the plaintiffs and appellees, Jay Patel and Deepika, Inc. I agree with Attorney Brooks in that there are two substantial issues in this particular case. The first being whether or not this court can actually hear a interlocutory discovery dispute, for lack of a better term, on a Superior Court order. And if ultimately the court does decide that the actual merits of Judge Locke's decision, utilizing the standard of clearly erroneous, or in certain cases with attorney-client privilege, also the de novo standard. And I suggest to you that because it is a case of first impression, I assume that my brief starts with some federal case law, in particular the Mohawk case, where Justice Sotomayor addressed this issue in 2009 on behalf of the Supreme Court of the United States. And it also deals in great part with the present exclusion as addressed by Attorney Brooks. But I believe because it's first case of first impression, you look, and if you look at the case law, and in particular Borman, where it talks and relates to two particular doctrines are very closely related. And I believe that the important relation to both of those is really the curability of the issue with respect to what happens to final judgment and the respect that this court must give to final judgment and not interfere piecemeal with the adjudication of a case being processed in the Superior Court, or in that matter, even a lower court. With respect to those issues, the court has consistently held that they do not interfere with discovery issues. Now, granted, the attorney-client privilege is something different. And that's why I believe we're here today. But I still suggest to you, or my client suggests to you, that this court should not render a decision on the merits, but look to both Borman and Mohawk with respect to what it should or should not do. The issue here with, and specifically in Mohawk, is at final judgment. Can some type of order, hypothetically, if this goes to trial, and that's a big hypothetical. You know, if you look at the history of this case, it was filed in December of 2015. If you look at the docket, it should have gone to trial almost a year ago in December of 17. Here we are in September of 18, still resolving these particular issues, not having conducted the deposition of Attorney Levin, which deposition would still go forward on certain issues regarding, where he was and all those other matters that don't get into attorney-client privilege. But with respect to how this court could remedy the situation, if hypothetically it goes to trial, and hypothetically the court rules on some issues of attorney-client privilege, it can come before the appeals court, or ultimately this court. And if it's determined that the decision of the attorney-client privilege at that time was erroneous, or whatever standard might be applied, that it be remanded back to the Superior Court, and that the Superior Court craft an order sufficient to protect the defendants in this particular case, again, should this occur. It happens all the time with respect to motions to suppress or other matters where a police officer may do an illegal search and seizure, come across evidence that's excluded, as is the fruit of that, the fruit of the poisonous tree. And that is the remedy here, is you have to look to public policy, the public policy being the expediency of the courts. And I'm not suggesting to you that without a remedy, public policy and speed by itself is not sufficient, but the ability for the court to handle its own docket and all the issues spoken or addressed in the Mohawk case go directly to that particular point. And I also believe in the Borman case, where you had a situation where, in that case, is a little bit different factually because of the fact that Attorney Levin is willing to testify, and the contempt issue is not, for lack of a better term, in play in this case. However, if you read Mohawk, the ability to hold yourself in contempt or take that stance is a option, not the option. I believe if you read the case in its entirety, the true relief here is what I just spoke about previously with respect to the court crafting a decision later on if, in fact, there is a mistake or an incorrect ruling at the Superior Court level at trial. It's also important to note that there's a footnote in the Mohawk case where it talks about, if this was an issue that was not handled correctly and it refers to the district court and the federal district court, but I would suggest that also applies to the Superior Court, that these matters are given great scrutiny. Justice Locke, on a discovery issue, held a hearing with 4 or 5 witnesses for the better part of a day and a half to 2 days on this particular issue. And he was the party that heard all the evidence. He was the party that was there and could see what body language the witnesses...
He seems to think that because it's a conflict of interest to represent both, that, the lawyer wouldn't have represented both. There's some circularity to that. I mean, there's also the possibility that the judge is sort of overvaluing complying with the ethics rules in the sense that he was representing both. He shouldn't have been representing both. And, I mean, they're paid by both sides. He seems to get his guidance from the side that's not representing him. Isn't that just erroneous, that finding?
I believe that, I can't...
It looks
I
like.
can only look at
and
the
also,
record. I
he's
can't
an
climb inside
historic-
Judge Locke's head, but
Well, Judge Locke says, look, this would be an ethical problem to represent both sides, and he's right. And I think he's just giving the lawyer too much credit here, maybe. But it looks like one person is representing both sides. He's taking direction from both sides. He's getting paid by both sides. That just seems problematic.
well,
It doesn't have consent. There's a way of doing this, which is to get written consent to do this. They don't do this. And then they bring in this sort of quasi-lawyer who doesn't do anything.
I'm not suggesting that Attorney Levin handled this correctly by any stretch of the imagination. But I also look to the parties, and in particular Mr. Martin. Judge Locke, in his order, referenced that Mr. Martin was the agent of Marcus and the trust. And I was remiss in my brief. In preparing for this argument, in the record appendix, pages 80 and 81, there's an affidavit of Mr. Martin where 6 specific times, and this would be more in the de novo, because I can't tell you if Judge Locke relied on that or not. I'm not going to misrepresent that he did. I don't know. It's part of the record appendix. It was part of the complaint. But in that affidavit, Mr. Martin, on 6 separate occasions, refers to the Masons and their attorney. Now, they talk about the fact that, yes, that nothing that says, well, I'm not, he's not my attorney. But I would suggest to you that I certainly have not. I get up here this morning and said, I'm the attorney for Patel and Deepika. I certainly didn't say I'm not the Masons' attorney or I'm not Mr. Martin's and Mr. Marcus's attorney. But more importantly, if you read that affidavit, it's what's not in there. When he refers to notice, he said, I gave notice to the Masons and their attorney, and then separate times them to Attorney Levin, their attorney, and throughout that affidavit. But then when he refers to me, he never says, I didn't get this or my attorney. The omissions in that affidavit, and that affidavit was executed, I believe, in March of 15 or 16, clearly a year or two before this all came about in June of 17. And people are held to what they put under oath. And I think if the court looks at that, at the merits of this particular case, you can, read and say, well, Mr. Martin's saying that David Levin was the Masons' lawyer.
Am I correct in my memory of the record? Didn't he at one point, wasn't there some suggestion that he was actually negotiating the purchase and sale with Mr. Levin on some points?
Martin, there was certainly, the record would reflect that a prior purchase and sale agreement was either drafted by Attorney Levin and there were amounts put on there, and again, without conducting the deposition of Attorney Levin and going into that matters, because obviously the justice wouldn't allow me to go there at the motion, though I tried. I don't know. But yeah, I certainly think that interpretation is fair for the court to make.
Just to step back on present execution. So the issue of whether or not the attorney-client privilege applied can certainly be addressed on appeal. However, you can't put back the value of the confidentiality of attorney-client privilege. That can't be unwrung.
Well, certainly for the purposes of the litigation, you can craft an order so that it wouldn't affect it. On collateral matters outside, I'm not going to suggest that you can't take back words. You can't put the genie back in the bottle. No, I would agree with the court on that. But with respect to the case itself.
You can take notice, or as we have done in many, many other circumstances, that courts can order somebody to disregard something or keep something confidential, no?
Absolutely, yeah. I think that in that particular case, thank you, Your Honor.
Is that the same issue for every privilege that we might decide? Is there something different about the attorney-client privilege that makes it subject to present execution as opposed to other privileges?
I would suggest, I mean, there is something different about as an attorney. I firmly believe there is something different about
Right, I
attorney-client
mean, I
privilege.
think
but
that might,
I'd be
might
disingenuous to
counter
the
your
court.
argument.
But what I had, no one's citing me.
Right, right. I mean, I guess that's the ironic part of it, right? Where do we put the attorney-client privilege as respect to other privileges we have, such that it should be subject to present execution where other privileges maybe aren't?
Well, I think it, you know, if you do the analysis, I think it can be cured, and that's the issue. And that's really the issue. Because of what the harm is that if we have interlocutory matters being appealed before the appeals court on all these particular issues, the wheels of justice are just going to grind to a halt. And you know, and again, expedience isn't the only answer, but litigation takes years as it is. And to allow something that can, and it's not going to be perfect, and I'm not just going to suggest in this court, and certainly when it comes to areas of the court's discretion in running the courts, sometimes perfection is put aside for the ability to run the courts in a smooth and efficient manner. And I believe that Judge Sotomayor addresses that in her decision in Mohawk.
In this case, is the issue of the attorney-client privilege collateral to the litigation, or is it tied up within the litigation?
I would suggest that it's probably not collateral, and that the judge, Attorney Levin, was involved in such a degree that he's a major component within the issues involved, especially considering that the fact you have under the case, you have the seller, the purchaser, and my client, the assignee, where the assignee by prior counsel, and again, in the history of this case is that and to his predecessor counsel, prior counsel for the plaintiff, passed away.
If you lose this litigation, you've not lost the case. If you lose this motion, you don't lose the case.
I certainly will. The concept of discovery is, what is reasonably calculated to lead to the admissibility.
Right, but you say it's not. This is not collateral. The result of this case it may affect pragmatically the outcome of the litigation, but it doesn't determine the outcome of the litigation.
No, it won't determine it, but it may determine it. Depends on what he says. I don't know. As with Attorney Brooks, I have no idea what Attorney Levin is going to testify to if he's allowed to.
Right, let's assume Levin believed that he was the attorney for the trustees. Right now, if it's a Fifth Amendment privilege, you can always get heard by an appeals court. You just have to go into contempt. Do we want to push attorneys who believe that there was a privilege and wanted to be heard by an appellate court to go into contempt?
Well, this wouldn't occur in this case, but I will answer the
Right,
court.
no, I understand that, but I
hypothetically, I'd be hard-pressed to believe that the appeals court or this court would provide sanctions on an attorney who rightfully and firmly believed that he was standing by his honor and protecting the attorney-client privilege. I do not believe that those...
Would that be any different if it were a priest-penitent privilege and the priests were possibly in contempt?
It's akin to it. And but if again, I don't sit on the other side of the dais, but I do believe that in the Commonwealth, I again would be hard-pressed to believe that an attorney would be held in any ethical jeopardy for taking an ethical stance. And I believe that is what would occur. Now, again, I don't know. That is just my opinion and the high regard I hold for the courts of the Commonwealth.
And does it matter here that opportunity for the attorney to go into contempt is not available because he's prepared to testify?
That is true, Your Honor.
And what consequences does that have here?
It has consequences. It has that the ultimate remedy would not be that. And if you look to Mohawk, it is a remedy, not the remedy. The remedy would be a appeals court, assuming it goes to trial, assuming this becomes an issue, then crafting an order and remanding it back down based upon that order and drafting a remedy that we talked about to protect the interests of the defendants in the event that this were to occur.
Okay, thank you.
Thank you so much.